And then I guess before we do get started, I see a new face, Matthew Tolnay. I'm assuming you're from the city attorney's office.
That's correct, Adrian. I am taking over for Mark Vaney. I am a deputy city attorney with the city attorney's office, and I've been with the office for a few months and excited to be here. Nice to meet everybody.
Welcome. Is that my understanding that Mark took a different job?
That's correct.
Okay. Well, good day for you to join us. Jump right into two investigations. All right, if we're ready to get going, then I'll call us to order since we have a quorum.
I'll call the roll. Lou Silver,
Present.
Tom Pavel.
Here.
Balthazar informed us that he was going to be absent this evening, and Adrian Gonzalez.
Present.
Thank you.
Thank you. All right, I call this meeting to order on Wednesday, December 8th, 2022 at 5:34 p.m. Welcome, everyone. Now that we've done roll call, let's do orders of the day. Is there a motion to approve or amend the agenda?
I move we approve the agenda.
Second. All right. Motion from Vice Chair Silver, a second from Pavel. Now move to a voice vote.
Lou Silver,
Yes.
Tom Pavel,
Yes.
Adrian Gonzalez.
Yes.
Thank you.
Seeing that, motion carries and the agenda is adopted for today. Seeing that there is nothing listed for closed session under item 2 on the agenda, we'll move on to item 3, public hearings. Our first item, we have 2 public hearings today, so we'll start with the first item A, hearing on a complaint filed by Francis Herbert. All right, so at this time, I call this hearing to order. It is Thursday, December 8th, 2022. And this hearing of the City of San Jose Board of Fair Campaign and Political Practices is called to order. 3 members of the board are present. Board member Lopez is absent today. The board will conduct a hearing on the complaint filed with the city clerk on October 17th, 2022 by Francis Herbert, alleging that the California Association of Realtors violated sections 12.06.910 of the San Jose Municipal Code, alleging a failure to properly file a 24-hour expenditure report. The city clerk promptly notified and provided a copy of the complaint to the evaluator, and the evaluator notified and provided a copy to the respondents, along with a copy of the board's regulations and procedures on October 27th, 2022. The evaluator's report and recommendations were submitted to the city clerk on November 15th, 2022, and copies were then provided to the complainant, respondent, and board members, and posted to the city website with the agenda for tonight's hearing. The board's regulations and procedures pertaining to investigations and hearings are established by Resolution 79-187. These regulations and procedures have been adopted in order to ensure the fair, just, and timely resolution of complaints before the board. This hearing is open to the public and is being electronically recorded. The formal rules of evidence do not apply to this hearing, but all testimony will be under oath or affirmation. The complainant will be treated like any other witness to provide evidence. The chair may compel the testimony of witnesses and may compel the production of relevant documents by the evaluator to the evaluator by subpoena. Witnesses may be excluded at the discretion of the board. Board members may ask questions of witness or the evaluator when recognized by the chair. At this time, I'd like to have the complainant, Francis Herbert, and the respondent or their representative from the California Association of Realtors identify themselves for the record. We will start with the complainant. Is Francis Herbert or a representative in attendance today?
There is no one by Francis's name in the attendees, but if there's a representative, please raise your hand and we can allow you to speak. And there are no hands raised.
Thank you. At this time, we'll go to the respondent. Is there a representative from the California Association of Realtors present today?
There are no hands raised at the moment.
Thank you. I would also like to have city staff and representatives of Hanson Bridget, the board's independent evaluator, please identify themselves for the record. Let's start with the city clerk, city attorney, and then the independent evaluator.
Hi, I'm Tony Tabor, City Clerk.
Hi, I'm Matthew Tolnay, Deputy City Attorney, City Attorney's Office.
And Stephen Miller from Hanson Bridget, and I'm joined, one of the attendees is Trevor Taniguchi, who's also from my office.
Thank you. Under the board's regulations and procedures, the respondents may submit a written response to the report and recommendations. These responses may contain legal arguments, a summary of evidence, and any mitigating or exculpatory information. At this time, it is my understanding that no responses have been submitted. Is that correct, City Clerk's office?
Yes, that's correct.
And is this also correct for the complainant's party?
Yes, that's correct.
All right, thank you. Before we proceed with the formal presentation of evidence, the board will accept public comment about this matter. Each speaker will be limited to 2 minutes. Are there any members of the public who wish to speak during this hearing?
There are no hands raised.
Thank you. So we'll now move on to the report and recommendations. At this time, I'd like to recognize Stephen Miller from Hanson Bridget to present the independent evaluators report and recommendations. Mr. Miller, the floor is yours.
Thank you, Chair Gonzalez. Good evening to you, sir, and to the rest of the board. You have a report from me, and so I will be very brief, and I hope you will agree with me that it's a relatively straightforward matter, so also merits brevity. The municipal code requires independent expenditure committees to file campaign disclosure reports at the times required by the Political Reform Act, such that a failure to file a report in violation of the Political Reform Act is also, by association, a violation of the municipal code within the jurisdiction of this board. The Political Reform Act requires what we call 24-hour reports, which are reports on independent expenditures that are made within 90 days of an election, and that must be filed within 24 hours of making the independent expenditure. The theory here is that the public should know about expenditures and who's making them before the election, and that filing a report quarterly after the election on an IE made in the days leading up to an election would, that information would come too late to be of benefit to the voting public. And the complaint alleges that the respondent here, the California Real Estate Independent Expenditure Committee, made an independent expenditure in the form of a mailer opposed to the election of Cindy Chavez for mayor, and did not file the required 24-hour report. Our investigation revealed that the respondent indeed made an independent expenditure on October 12th, 2022, but that they properly submitted a 24-hour report on October 13th, within 24 hours of the expenditure. Apparently, there was some sort of technical glitch that prevented the city clerk from receiving the report, but it was submitted on time. We verified the date stamp on the fax machine and spoken to the city attorney's office. We also take heart in our conclusions because the complainant also filed a complaint with the FPPC, which similarly investigated and ruled in line with our investigation and found that there was no violation because the report was in fact submitted on time. So accordingly, we recommend that the board find that there was no violation of the municipal code because the 24-hour report was in fact submitted on time. And that concludes my report. I'm happy to answer any questions.
Thank you,
Yes,
Mr.
please.
Miller. Vice Chair Silver, please.
Oh, you are muted.
Well, for fear of being too lawyer-like, we talk about, something happening within 24 hours of the expenditure. Is it really the expenditure, or is it when the flyer hits the airwaves? I mean, in theory, someone could have paid for it 10 days before it was mailed. And so I don't know what make the expenditure means.
I see. That is an interesting question. I don't know the answer, to be perfectly candid, off the top of my head. If they paid for the expenditure on day one and then actually mailed out the mailer 30 days later, do they have to file the report on day 2 or on day 31? I confess I don't know the answer to that question. You've out-lawyered me, Director Silver.
All right, I'm ready to retire. And I'm ready to make a motion that we accept that we rule against the complainant for two reasons. First, for the reasons set forth by Mr. Miller, that the facts show that it was timely filed, and because there's no prosecution. I don't know whether we should simply assume that the complainant accepts, although grudgingly, the ruling. So I would move that we dismiss the charge.
So before we go to that, I have a couple of questions of my own, if that's okay.
Yes, go ahead, board member Pavel.
So I was curious. Well, there's a few questions around this date of when the mailers were actually went out, or or when the expense was incurred, as the previous question just got into. But my first question is, there seem to be two different Form 496 forms in the attachments. The one in the response from the FPPC is dated 10/7 and has a different cumulative total, a smaller cumulative total than the form dated 10/13, which suggests there were two separate mailings for the same $66,203. Do you have any insight into that, Mr. Miller?
So I'm heartened that you looked at our exhibit, so thank you for that. I also noticed that discrepancy. I do not know what the exhibit to the FPPC document really is. I received a copy of the Form 496 from the clerk's office, the one that was submitted to the city clerk, and that's the one that I really was focused on. So while I noticed the discrepancy or the difference that you mentioned, I don't have a good explanation because I don't know the source of the report that's attached to the FPPC
you didn't check
document.
with the city clerk that there was a second 10/7 filing in addition to the 10/13 filing?
I did not specifically ask that question, although we could do that today. The clerk is here if you like. Yeah.
My other question is, what evidence do we have that the expenditure was on October 12th? It sounds like we have the date in the Form 496, but we don't have any independent corroboration of that, right?
That is correct. The matter under my investigation was the form filed in the time required by the form, and not when was the expenditure itself made. That sort of is related a little bit to Director Silva's comment of what is the date that triggers the 24-hour report? Is it the postage stamp on the report, or the paying the check to the graphic design company that produced the mailer? And that's, I made light of it, although I'm now kicking myself that I didn't anticipate and answer that question, so I don't have an answer to that.
Yeah, I mean, I guess we certainly can't, so the October 12th date on the form, seems like that's the best information we have. The complainant suggests that the date was on or around October 10th, which the 12th would be around the 10th. But if in fact the expenditure was on the 10th, then the form would not have been filed within 24 hours.
That's everything. What you say is correct. The complainant was not, didn't have access to this report because it was not posted, because it was caught in this technical glitch I mentioned. So that's where I believe the on or about comes from. I don't think the complainant is disputing the date of the expenditure. They were just complaining that there was no report filed, period.
You did not have a chance to interact with the complainant?
I did not. It's not just to be clear, it's not that I didn't have a chance to. It's always a question for me whether or not my investigation depends on information that would require me to talk to the complainant. And in this case, I determined not to talk to the complainant. It's not that they didn't cooperate or I didn't have a chance. I did not reach out.
No, I understand. There was a statement that the complainant wanted to proceed with the complaint even after learning that the report was filed. But so you were not
Right.
involved in that. That was between the clerk's office and.
That is correct.
Okay. Yeah, it seems to me like, if there were a mailer with a postmark of October 10th or something, then, that would provide evidence that in fact it was not within 24 hours. But in the absence of any such evidence, I certainly seems to me like the complaint is not justified. But I sort of hesitate. I don't know if, can we say we have sufficient evidence to say that it's definitely not justified, or, if such a postmark were to come forward in the future, then, it would seem to me that they would have to reopen this or something.
Tom,
Yeah,
to
so
complicate that even-
Director,
No, I'm sorry.
Sorry.
To complicate
no,
it
I
even
apologize
further,
for interrupting you. Please go ahead.
this stuff goes out third-class mail, so it doesn't get delivered on the same day in different parts of the city. So, if the date of, if we are going to look for the 24-hour period to begin, I just make it factually more complicated. Is it the day that the mailers were delivered to the post office? Is it, the day the first one hit? Is it the day the last one hit?
Well, I do
So
sort
let
of
me
think
just
that
offer-
your earlier point about, when the expense was made, in other words, when the money was incurred, that's probably a more relevant date. But I'm just saying that if we had evidence that the mailer had gone out on the 10th, then that would suggest that the decision to make the expenditure, was before the 12th. Yeah.
So if I could offer just one more observation, I think I agree with you that it would have been more helpful to you all had I uncovered answers to these good questions you're asking. I think once I saw that the FPPC had made the determination that it did, there's only a violation of the municipal code if there is first a violation of the Political Reform Act. And so I sort of accepted the FPPC's determination and did not turn over the stones that you are suggesting might have been turned over. And it's not so much an excuse as just an explanation that I just sort of accepted the FPPC's determination as sort of shutting the book on this from my perspective.
Well, I agree.
It would be an odd result for the city to come up with a different outcome than the FPPC on this type of a matter.
I agree. I mean, it does seem like the situation is straightforward. My only hesitation was the sort of statement that the complainant still wanted to proceed even though the report was filed. And the only reason I can sort of come up with for that could possibly be the timing. But in the absence of any evidence or any statement, any allegation, I guess we have to go with that, with the date on the form.
Any additional questions for the investigator's report?
No.
Did the city clerk's office wish to add anything? I saw the mic go on and off a couple times.
No, I was gonna say that a lot on the billing, like when do you pay for it? A lot of times when we get something printed, we get invoiced after. So they may not have paid for the invoice before the mailers went out, but I don't think that's relevant, but it was like a question earlier on. They may have paid for it weeks early, but they may pay for it weeks later.
Yeah, I guess the invoice may go out later, but there's still some authorization to pay, right? There's some obligation to pay or something.
Yeah, and I think once they file their Form 460s on January 31st, you would see that actually. You would see the date of the invoice, I believe, on the 460. But I don't know if that's relevant.
Yeah, I don't know. Yeah.
Okay. I do have one general question, and maybe we can discuss a little more later on in today's meeting when we get to the biannual review. But I've noticed a little bit of a trend with this hearing and the last hearing we had relating to the allegation against the mayor and their disclosure alleged improprieties. And in both of these cases, there have been a delay in when the report was received and when it was publicly available, which has led to this type of complaint being filed. And I know in the report, there's a discussion about an IT glitch and it's been remedied. But I'm just curious if this relates to problems with the software we use for reporting, or is this more of a capacity issue and the manual time it takes for staff to review and process and upload files to the public? That might be a question for the city clerk's office.
I'm sorry, you cut out a little bit. What was the question?
Yeah, so in both, I noticed a little bit of a trend in this complaint and the last one involving the mayor, whereas there was a delay in reports from when they were submitted and when they were publicly available. And in the report here, we discussed an IT glitch and that it was remedied, but I'm just curious if it's actual technical issue with the software or if this is a capacity issue because of the manual time and labor it takes for staff in the city clerk's office to review, process,
Yeah,
and then approve or upload.
So anybody who's not filing through our system, there's a delay from the time it's received to the time we're able to upload it. Some people don't want to, they don't file with us enough. And I've offered to make them accounts so they can file electronically. They're not required to file electronically in our municipal code, and they don't want to. So the delay is just staffing.
Okay.
In this case, it was not staffing. This was, we just didn't get it until somebody told us we didn't get it. And then we were able to contact IT and work with them and find it. But that was just for this case.
Okay. Thank you for clarifying.
So you're saying that the fax was sort of in an inbox somewhere and didn't get routed?
There's multiple fax inboxes, and it wasn't in the one we normally check. It was in a different inbox. And now we've got that situation fixed.
Okay. And it's unrelated to the other issue that
yeah, this one was completely unrelated. We have a new fax system that we're still adjusting to, and that was the biggest issue, is we're adjusting to a new system. And there were multiple folders, but we didn't check all of the different folders because we didn't know there were more than one folder.
All right, so before we move on to final deliberation and a vote, I just want to make sure we follow our typical protocol. So after a review of the investigator evaluator's report, we typically then offer an opportunity for the respondent and complainant and or their representatives to provide sworn testimony. I do understand from the beginning of this public hearing that no one was present, but since some time has passed, I just want to offer one last time. If there is a representative from the respondent or complainant's parties, to please raise their hand if you wish to provide any sworn testimony. So at this time, I will ask for assistance from the city clerk's office to identify if anyone's raised their hand.
No one has raised their hand at this time.
Okay, thank you. Any final comments from the independent evaluator?
Nope.
All right. Now it's time for the board to make a decision. The board has the following options. The board may find that further investigation is necessary. If so, we can direct the evaluator to conduct further investigation and report back. The board may find that there is sufficient evidence to establish that no violation has occurred. The board may find that there is insufficient evidence to establish that the violation has occurred. And the board may find, based on the preponderance of evidence from the entire record of proceedings, that a violation has occurred. So at this time, I'll open it up to the floor if you wish to have any further discussion, or I can entertain a motion.
I guess I'd like to ask, what is our burden of proof for these matters? Is it preponderance of evidence?
Correct.
Okay.
Any other questions or comments from the board? I will accept the motion.
You're on mute, Lou.
Excuse me. Yeah, I'll move that we dismiss the complaint on the grounds set forth in the memo from the investigator.
So it's my understanding that Vice Chair Silver has made a motion that we adopt the evaluator's recommendation that we find sufficient evidence to establish that no violation has occurred.
Correct. That was your second option. And yes, that's what the motion is.
Thank you. Is there a second?
I guess I will second that. I think based on the preponderance of evidence standard, we don't have any reason to doubt the facts as presented. Yeah.
Thank you. Second from Board Member Pavel. Now I'll pass it off to City Clerk's office for a voice vote.
Lou Silver,
Yes.
Tom Pavel,
Yes.
Adrian Gonzalez.
Yes,
Thank you. That motion passes.
thank you. Now, upon the adoption of a motion, the chair must ask each board member to certify that they have heard or read the testimony at the hearing and have reviewed all the evidence in the record by affirming so certified. So at this time, I will ask the board members to say so certified when called upon. Board Member Pavel,
So certified.
Vice Chair Silver,
So certified.
and Chair Gonzalez, so certified. All right, thank you, everyone. That closes our first public hearing. Give me just a motion or a minute to move on to my second public hearing item. Okay. Anything from city staff before we begin the second public hearing?
So at the beginning of the meeting, I did note that we received a letter from the public and that was posted shortly before the meeting began regarding item 3B.
Okay, thank you. All right, so at this time, we'll now move on to item 3B on the agenda, the hearing on a complaint filed by Joseph Barco on November 1st. So it is December 8th, Thursday, 2022, and this hearing of the City of Board of Fair Campaign and Political Practices is called to order. 3 members of the board are present. Board Member Lopez is absent today. The board will conduct a hearing on a complaint filed with the city clerk on November 1st, 2022 by Joseph Barco, alleging that Irene Smith for San Jose City Council D3 2022 violated sections 12.06.1010 of the San Jose Municipal Code, alleging a failure to properly disclose political advertisements. City clerk promptly notified and provided a copy of the complaint to the independent evaluator, and the evaluator notified and provided a copy to the respondents, along with a copy of the board's regulations and procedures on November 4th, 2022. The evaluator's report and recommendations were submitted to the city clerk on November 29th, 2022, and copies were then provided to the complainant, respondent, board members, and posted to the city website with the agenda for tonight's hearing. The board's regulations and procedures pertaining to investigations are established by resolution 79-187. These regulations and procedures have been adopted in order to ensure the fair, just, and timely resolution of complaints before the board. This hearing is open to the public and being electronically recorded. The formal rules of evidence do not apply to this hearing, but all testimony will be under oath or affirmation. The complaint will be treated like any other witness in providing evidence. The chair may compel the testimony of witnesses and may compel the production of relevant documents to the evaluator by subpoena. Witnesses may be excluded at the discretion of the board. Board members may ask questions of witnesses or the evaluator when recognized by the chair. At this time, I'd like to have the complainant, Joseph Barco, and the respondents, Irene Smith for D3, or their representatives identify themselves for the record. We'll start with the complainant. Is Joseph Barco or a representative in attendance today?
Yes, I'll permit him to speak. I can also move them to the panelist side if you'd like, but I'll allow him to speak for now.
Thank you. Please just introduce yourself, Mr. Barco.
Good evening. My name is Joseph Barco, and I'm the complainant.
Thank you. You will be provided an opportunity to also provide sworn testimony in a few steps here.
Thank you.
At this time, I'd now like to provide an opportunity to the respondent, Irene Smith for D3, or the representative, if someone is available to introduce themselves.
So I see someone with the name Irene Smith is in attendance. If you'd like to speak, would you please raise your hand?
Hi, I'm Irene Smith.
Thank you for introducing yourself. You'll also be provided an opportunity to provide sworn testimony if you so desire in a few steps here. At this time, I'd like to also have the city staff and representatives Hanson Bridget. Please identify themselves for the record. Let's start with the city clerk, attorney, and then Hanson Bridget.
I'm City Clerk Tony Tabor.
Matthew Tolnay, Deputy City Attorney, San Jose City Attorney's Office.
Stephen Miller and Trevor Taniguchi from Hanson Bridget.
Thank you. And
Sorry,
the board-
Trevor, you could introduce yourself. I didn't mean to steal your voice, Trevor.
That's all right. Trevor Taniguchi.
Thank you for joining us. Under the board's regulations and procedures, the respondent may submit a written response to the report and recommendations. The responses may contain legal arguments, a summary of evidence, and any mitigating or exculpatory information. So at this time, we'll take a review. The respondent, can we confirm if any written testimony has been provided by the respondent today from the city clerk's office?
Yes, that's correct. It's been posted under item 3B.
Thank you. So under item 3B on the agenda for members of the public, you'll see a link letter from respondent 12/7/2022. The complainant or any interested party may also submit a written brief. Is my understanding that there's a letter from the complainant dated 12/8/2022 also on the agenda. Are there any additional records, city clerk's office?
Nope, just that one.
Thank you. Before we proceed with the formal presentation of evidence, the board will accept public comment about this matter. Each speaker will be given 2 minutes to speak. So at this time, I'd like to ask members of the public to please raise their hand if they wish to speak. I also want to clarify that this is still different from sworn testimony from individuals who represent the respondents or the complainants. So those parties, please wait until the sworn testimony portion. But at this time, I'd like to ask the city clerk's office to please identify if anyone from the public has raised their hand.
No one has raised their hand.
All right, thank you. So before we do sworn testimony, at this time, I will recognize Mr. Miller from Hanson Bridget to please give an overview of the independent evaluators report and recommendations. Mr. Miller, the floor is yours.
Certainly. Thank you. Good evening again, directors. Stephen Miller with Hanson Bridget. As with the last report, this investigation also deals with the relationship between the Political Reform Act and the Municipal Code. The Municipal Code requires that disclosures on advertisements be made in accordance with the Political Reform Act requirements. And the Political Reform Act has a relatively new requirement that specifically pertains to disclosures on what it defines as, quote, online platforms. This is a newly defined term. This is the first time that this board has considered this PRA, Political Reform Act requirement. Indeed, the FPPC, there's a paucity of, not an absence, but a paucity of guidance on it. It's a brand new regulation. The complaint alleges that the respondent, Irene Smith for Mayor Committee, advertised on an online platform under subject to the Political Reform Act, namely a website from the company Medium, without arranging for inclusion of the proper paid for by disclosure statements associated with the postings on Medium. Our investigation really turns on a purely legal examination of the Political Reform Act's definitional structure. There were no factual issues for us to reach, and we conclude that Medium is not a, quote, online platform subject to these new Political Reform Act rules, because Medium does not display advertisements, nor does it sell advertisements, and thus it is not it's not defined in the scheme on the Political Reform Act that would require the paid for by disclosures. And therefore, because Medium is not an online platform subject to the PRA, The respondents' postings were not subject to the PRA disclosure rules and therefore not subject to Title 12 of the Municipal Code's similar rules. And so accordingly, we recommend that the board find that there was no violation of the Municipal Code. You'll notice in our report, I don't know, a suggestion may be too strong a word, but at least a comment that this issue might be added, or specifically the Title 12's definition of advertisements might be added to what I still think of as Cecilia's list. I'm probably now one of the only, maybe two people on this call who know who Cecilia was, but that's, I think, what you call the biennial review list, Chair Gonzalez. Just to study to see if the board wants to recommend any revisions to Title 12 in light of this new Political Reform Act requirement. That concludes my report.
Thank you, Mr. Miller. Are there questions from the board? No questions. All right. All right. See Pavel?
Yes, sorry, hit the wrong mute button there. I guess maybe better taken up later, but I wanted to understand more about your suggestion about how to revise the municipal code, because it seems to me that that whole section is about political advertisements, and in this case, it sounds like no money changed hands, therefore it's not really an advertisement. So it's not clear how you would clarify that in the municipal code.
So if is that a question for me, Director Pavel?
Well, the question is, what if you could elaborate on what your suggestion was for changes, but perhaps that's an issue better addressed later in the meeting.
Well, so I have no hidden agenda. There is not a specific revision to Title 12 that I think is necessary. I just am now pointing out to you all that there is a new definitional scheme in the Political Reform Act, and it might be worth looking at the definitional scheme in Title 12 to see if it is still aligned with and harmonized with the Political Reform Act. It may well be that after that study, you all agree with the position you just took, Director Pavel, that we're all good and there's nothing more to do. I'm just pointing out that the branches of this advertisement definitional tree have now sort of diverged a little bit, and it might be worth looking at. I have no agenda behind that recommendation.
I mean, my understanding is the municipal code sort of imports the PRA's definition of advertisements.
Well, no, that's not entirely correct. The municipal code imports the Political Reform Act definitions unless there is a separate standalone definition in the municipal code, which now there is.
Okay. Okay, I understand better. Thank you.
Any additional questions for the evaluated investigator?
I might have some after the testimony. I'd like to hear what the parties have to say.
Okay. All right. So we'll now move on in the process. So we'll move on to sworn testimony from the respondent and complainants or their representative. So at this time, we'll start with the respondent. At this time, I call upon the respondent or the representative to come forward and present any written or oral testimony. Each speaker will be given 5 minutes to present. Is such an individual present and wishes to speak?
Irene Smith has her hand raised, so I'll allow her to speak now.
All right. Irene, so before we begin, since this is sworn testimony, we do have to go through a little procedure. Are you willing to come on camera?
Yeah, sorry. There I
Thank you. So please raise your right hand and state your name for the record.
Irene Smith.
Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, you may proceed. You have 5 minutes to provide testimony.
Thank you. I don't have much to add to my letter that I wrote, and I guess I want to specifically thank Stephen Miller and company for a really thorough investigation. And I couldn't agree more with the decisions that Medium is not an online platform. It is not an advertisement. My campaign did not violate Title 12 nor the municipal code. And my campaign did not violate the recently updated Political Reform Act. And my campaign did not violate the California Fair Political Practices Commission's regulations. In addition, the Political Reform Act's recently enacted requirements for advertisements on online platforms do not apply in this case because Medium is a blog and it is not an online platform as defined. And importantly, even if the municipal code Title 12 was updated, it would have no impact on this case because again, Medium is not an online platform under the federal government code. And it neither sells advertisements nor displays advertisements. And one thing that I think that was left out that we should probably talk about is that Medium as a blog, and that's defined under the Political Reform Act, and it does not require a statement. So that's pretty much a summary. You have my letter, and I respectfully request a dismissal with prejudice.
Thank you, Irene. Do you wish to stay on to accept any questions from the board?
Oh, sure.
Do the members of the board have any questions for the respondent? Okay, seeing that there are no questions, we thank you for your time and coming forward to provide testimony, Irene Smith.
Thank you.
Thank you. At this time, I'd like to call upon the complainant or their representative to come forward and present any written or oral testimony. The speaker will be provided 5 minutes to speak. Is such an individual present?
Yes, Joe Barco has his hand up, so I'll move him to the panelist side.
Thank you. Hi, Joe, can you hear? Or can you speak? Your mic's on mute.
Yes, I apologize. I was making sure I was set up today.
All right, since this is sworn testimony, I'd like to request that you raise your right hand. Please state your name for the record.
Joseph Barco?
Do you swear that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
All right, you may proceed. You have 5 minutes.
Okay. Thank you to the committee and thank you for Mr. Miller and Hanson Bridget for investigating the complaint. I submitted my letter already. I agree with the results of the investigation. I agree that Ms. Smith did not violate the Campaign Disclosure Acts, as she stated earlier. I think there was merit in asking for the investigation based on the results, but I do ultimately agree with the outcome. I also agree that she is correct in that changing the disclosure rule still qualifies Medium.com as a non-paid advertisement. So everything else I have stated in my letter for the record. That's
Thank
all
you.
I have to say.
Are there questions from the board?
So I do have one, which is that in your letter, you talked about a desire to see the municipal code clarified in this regard. Could you elaborate on what kind of clarification you'd like to see?
Well, I'll describe the situation, which is I'm not a lawyer, and I read the rules. I looked at the municipal code. I went to the California code to review it, since it just references that, and directly looked through multiple definitions. The law in multiple places looked at memos to try to understand, okay, this looks like a paid site, and that's why I filed the complaint. So that was clearly incorrect. Mostly it is, I would agree with Mr. Miller, which is to align the definitions of what's an online platform and an online advertisement with what the state says.
Okay, so if I could just restate to clarify, so your confusion was more around the factual question of whether Medium was paid advertising or not, rather than about the definitions.
I think that's fair to say, yes.
Okay, thank you.
Any additional questions from the board?
I don't really have a question for Mr. Barco, and procedurally, I don't know that we've discussed this, but I would think you should have the opportunity to withdraw your complaint if you agree with the investigation. or permit us to rule against you. I think you probably have that option.
Do I have the option to withdraw the complaint?
In my almost 8 years on this board, we've never encountered this issue.
I'm perfectly willing to accept that I'm wrong in this instance, and I believe I said so in my letter. So I am not going to be upset or offended by losing here. I felt like I raised legitimate issues that clearly were legitimate, given that they merited an investigation, and I'm accepting of the outcome of that investigation.
Okay, thank you, Mr. Barco. So at this time, since I have policies of how to conclude the public hearing, and I don't have any policies about how to withdraw, I don't think that's within the structure that City Council's provided us. I will move forward in finishing the public hearing. But that was a good question, Vice Chair Silver, and maybe we can incorporate that as a suggestion in our biannual review. Okay, so at this time, we've concluded sworn testimony from the respondents and complainants. So at this time, we'll provide an additional opportunity if the independent evaluator has any final comments to provide before we move on to deliberation.
No further comments from me. Thank you.
All right, so at this time, the board will make a decision. The board has the following options. Number one, the board may find that further investigation is necessary. Number two, the board may find that there is sufficient evidence to establish that no violation has occurred. Number three, the board may find that there is insufficient evidence to establish the violation has occurred. And number four, the board may find, based on preponderance of evidence from the entire record of proceedings, that a violation has occurred. So this time we'll open it up for discussion before we take a vote. If there's no discussion.
I don't have anything further to discuss.
Okay, I am open to motions.
I guess I'll make the motion that we find sufficient evidence that no violation occurred.
There's a motion from Board Member Pavel to find sufficient evidence no violation has occurred. Is there a second?
Second,
From Vice Chair Silver, we'll now move to a voice vote.
Lou Silver,
yes.
Tom Pavel,
Yes.
Adrian Gonzalez.
Yes,
Thank you. That motion passes.
thank you. All right, so upon adoption of the motion, the chair must ask each board member to certify that they have heard or read the testimony at the hearing and they reviewed all evidence in the record by affirming so certified. So at this time, I'll ask each board member, Board Member Pavel,
So certified.
Vice Chair Silver,
So certified.
and Chair Gonzalez, so certified. Seeing that, the complaint is dismissed and closed without further action, and this public hearing is closed. Thank you, everyone. Let me get back to my agenda.
That was relatively painless.
We've
Well,
had harder public
Thank
hearings.
God. Glad you thought so.
All right, we are now back on the agenda. Item 4, public record. There's nothing to review. So I'll move on to item 5, consent calendar. Is there a motion to approve the consent calendar or make any amendments?
Move we accept the consent calendar.
I will
Okay.
second.
Motion from Vice Chair Silver and a second from Pavel. Now move to a voice vote.
Lou Silver,
Yes.
Tom Pavel,
Yes.
Adrian Gonzalez.
Yes,
Thank you. That motion passes.
thank you. The consent calendar is approved. Moving on to item 6 on the agenda, reports, sub item A for the chair. I have nothing at this time, but I'll pass it off to the city attorney's office.
Chair Gonzalez, if I could interrupt you just for 1 second.
Yes.
This is often the time in this meeting where you dismiss me from the hearing, from the meeting. I'm happy to stay on and participate if you're going to be discussing anything where my input would be desired, but I wanted to give you the opportunity to send me packing if that's your pleasure.
Do we want to keep Mr. Miller on for the biannual review conversation, or did we get sufficient guidance to carry it on from there?
Yeah, I think we can let him go.
Yeah, I agree. I think, I did already ask that question and he answered it, I think, is to the extent that we'll get from him.
All right, Stephen and Trevor, you all are dismissed. Thank you for your time.
Thank you very much. Nice to see you all. Nice to meet you in person or over the Zoom sphere. New City Attorney Tomei. Look forward to seeing you in the coming year. Bye-bye.
Nice to meet you too. Bye.
All right, so we'll pass it off to the city attorney's office.
Thank you, Adrian. I don't have an update on the legislative history or on elections, but my predecessor before he got out received two separate inquiries about various issues that came up, and he opined on them. They were both attached to the agenda. One of them was a question about the use of campaign funds that were received to, I believe, pay for a luncheon, and then also to use funds for existing legal challenges related to the campaign. My predecessor answered Mr. Bainey that that was permissible conduct. There was another letter that was received, and it was concerning an update to the municipal code about the ability to continue to receive campaign contributions 60 days after the election. And Mr. Bainey provided a response and also provided a link to the updated code provision indicating that that's permissible so long as it is contributions that are for the receipt of debt and liabilities from the campaign. That's the only update I have in those two matters.
Thank you. Other questions from the board?
No.
I have some general questions. So with the transition from Mark to yourself, Matthew, will this be kind of an interim placement, or do you anticipate that you'll be working alongside us for the foregoing future?
For the foregoing future.
Okay, and maybe we can discuss a little more in the old business section, but there were kind of a series of
Outstanding
policies.
items.
Yeah, okay. All right, sounds like you're aware. We'll talk about them then. All right, no more questions for the city attorney's office? All right. Thank you. We'll now move on to the city clerk's office.
Sorry, I'm opening my camera up. So
That's
I
not
put a
San
couple,
Jose.
no,
Or
that I
Monterey.
think is a
Winter Wonderland
German,
there.
I think it's a German Christmas market. I was just looking for like Christmassy pictures, but weren't too Christmassy.
Very nice.
I do have some that are really, really Christmassy though, if you really want one. So I put a couple of links. I have so many windows open right now. I can't find it. I know one was a link to the memo from Councilmember Esparza that went to rules to clarify some issues in the municipal code. I just wanted to make you guys aware that that item went to rules. Megan was at that meeting because I cannot remember how it was voted on. Megan, do you remember if it got moved to council? I don't know if
Sorry about that. I was just grabbing it. Let me look. So C3 was approved to be agendized for a council meeting in early January, and with direction to the city attorney to look into limitations, legality, and liability of prohibiting sitting council staff from working for or chairing independent expenditure committees, and also amending the revolving door policy.
So that will be coming to council in January. I wanted you to be aware. And then the other issue is to just give you a an update in case you didn't see it in the paper. We did have a meeting on Monday to discuss the and unanticipated vacancies in council districts 8 and 10. The council voted 7-4 to appoint instead of calling for a special election. And there was, presentation on Monday if you want to watch it, unless maybe you already did watch it. So Joy, I think, wrapped up the application changes today. So that application, it's currently live, but I will be sending out an email tonight after this meeting to the council offices and I have a mailing list of about 280 people and organizations. So it'll start going out to them. I'll send it to the city manager's PIO officer and ask her to put it on her social media as well. So it'll go out tomorrow. but you can see the application tonight.
Okay.
We have to make it live in order to edit it. It's crazy. So it kind of went live when it was still in draft form, just because it was the only way the software allows us to edit the application. So those are the two big election related items that have come our way since our last meeting.
So question on the first item, there's obviously some overlap between the memo there and what we had last month asked
Right.
that the city attorney's office work on drafting some changes to the code. Is it appropriate to sort of reach out and try to make aware of this work we have in progress, or?
Well, I can, when it goes to council, we can talk about that. Sometimes when the council gets a referral like this, they'll refer it back to you guys for your input. So that's something that we can let them know in January when it's scheduled, that you guys have looked at this issue.
Or have looked at some aspects of this
Right.
issue.
Yeah, you haven't, right. You haven't looked at the specific memo other than to just be informed that it exists. And they may want to send it to you guys for review. I'm not going to promise that though.
Yeah. Well, what I was wondering is whether it's worth sort of sharing the memo that we had to kind of give them some context of what we were discussing.
Yeah, we can. We can attach it as an exhibit for that item.
Okay. Great. Thank you.
Any other questions for the city clerk's office? Do we have? Are you finished with your report, Tony?
Yeah.
Do you have an update on the board expenditures with the these two complaints today? Or I guess he still has to bill for the time for today as well.
Yeah, I don't know, because the bill actually goes to the city attorney's office. So it takes a while before it filters to our office where we get the numbers. So the attorney's office may have all of the bills, but I just may not have gotten the expenditures from them yet. Because
Okay.
the last I saw was Mark was saying he was going to get the numbers to somebody who requested it. That wasn't me, but I don't know if he sent the numbers. So Matthew,
Certainly
that'll
something,
be on you.
certainly something I can follow up on. I
Yeah,
haven't
I-
seen the numbers either.
Thank you. All right, so that'll conclude item 6C on the agenda. We'll now move on. I've seen that there's not, we've dismissed Mr. Miller and Hanson Bridget. We'll skip sub item D and move on to item 7 on the agenda, old business. Sub item A, discussion of the biennial review. So I guess at this time, first I'll start if the city staff have any new thoughts or recommendations with anything pending with the city administration.
No, not on my end. I'm not sure about city attorney's side.
Matthew, are you briefed and familiar with the review?
Somewhat. I'm aware of the process and some of the items that might have been addressed, but I'm guessing there's much more for me to learn.
Well, this past year we did a lot of individual referrals, so this year's biennial review isn't super complex, but essentially, as you can see in the agenda, we have this matrix where we just try and track administrative items and things related to the resolution or procedures that we want to make recommendations on. We've kind of had this as a regular item on our agenda just to check in month to month what we want to add. If I remember correctly, Tony, we would like this done by January, February.
Yeah, I think we said February. I should have said in our update that we have terms ending in February for, I think, 2 of you. So we would like to have it done in February. Those of you who are eligible for reappointment, reapply, and we'll be bringing appointments to council in February. So yeah, it would be great if you guys could do it in February before you lose brains.
Yeah, okay.
So I was going to ask a question. The two items that we discussed last week that came out of our subcommittee that we wanted to refer to the city's attorney's office, they didn't make it onto the matrix. Is that part of the process that they go after the city attorneys have a draft, or should they be on that spreadsheet now?
I think for the purposes of us having some recent transition and soon to be transitions, it's good that we just put them on the matrix. So if we look at the matrix, we see, where am I? What file? Okay, so we have the PRA. So I guess let's start with that since it's on there. Matthew, were you briefed by Mark before he left on the PRA issue?
This is the sixth one on the matrix. No, I was not.
Okay. But you're gonna have a fun task. So we had provided direction as a board to the city attorney's office. And maybe the city clerk's office can help you find the right records, but I think sometime in the spring or early summer, we had a hearing that was related to one of our powers in the municipal code to act as an appellant for public records requests that were denied by city staff. And we were kind of in this awkward position where we couldn't review the records because the city attorney's office had declared them as privileged and confidential. So we couldn't actually review the records to really make a determination until we just referred it to the city council. And so what we had requested from the city attorney's office was to review the current language in the municipal code to help clarify what specific records we can review as a part of the appellate process. Because if the city's taking the stance that there are certain records like those that are claimed as privileged, I mean, there's really no role for us to play in the appellate process if we can't review the records. And I know under state law, there's like different categories of records that can be appealed. So we would just wanted to make sure that the municipal code was a little more clear so that members of the public knew what records they can and can't appeal through us.
Okay, that makes sense. And this is the same timeline to be completed at the beginning of the new year, prior to February, to have an overview from my office about stance on what issues or what records can be reviewed. Is that correct? Okay.
Thank you. Any other thoughts on the PRA before we move on? Okay, so there was another item. Pavel, what were you thinking of?
Well, so last month, we discussed sort of two recommendations that came out of a subcommittee with board member Lopez and I. One was a set of suggested changes to the municipal code to clarify things that came out of the previous complaint about common good Silicon Valley, which so this has to do with office holders and what rules apply to office holders and what restrictions or what things are unrestricted. So it's just trying to make the code more clear in those regards. So that was, there was a memo with a set of recommendations there that needs to be looked over, or legal considerations need to be applied to those suggestions, right? So they're just starting points. They're not, the final text, but it's fairly well fleshed out. So that's a potential set of changes to the municipal code that needs some legal review in order to move forward to propose to the board. And then the second suggestion that came out of the subcommittee was much less well developed, and that was looking into what kinds of disclosure requirements we could add to independent expenditure committees that are sponsored by 501c4 organizations, nonprofits, and that the sort of which was a structure that came up in that particular case. And we sort of anticipating that that could be a problem in the future. And Mark had some thoughts on that, and he was looking at what other municipalities like City of Santa Clara and some others he had in mind. And unfortunately, I did not get a sort of brain dump from him before he left of what exactly he had in mind. I suspect he didn't transfer that to you either. But I am I'm looking forward to, and whenever you have a chance, maybe you and I, as part of this subcommittee effort, can discuss that in some more detail, and we can see what thoughts you have on that.
Absolutely. This one, I think I got a reference to from Mark, the second.
Oh, great. Great.
And on the first recommendation, you mentioned the memorandum. Had that already been forwarded to my office?
Well, it was in the package for the last board meeting, but
Okay.
we can forward it. If you don't have it, we can definitely get you a copy.
I can pull it from there, and I'm assuming Mark has it in one of the files I have access to as well.
Presumably, yeah.
So my recollection is at the last meeting, we took a formal vote to provide direction to the city attorney's office to help draft language that would implement that memo that Pavel put together. So yeah, I would agree with your approach, Pavel, if you guys can meet sometime before our next board meeting and just help fill in.
Yeah, I guess, Matt, just let me know when you sort of caught up and have time to meet. I'm relatively available.
I can do that. Thank you. I greatly appreciate it.
Are there any other items that we want to add on to this matrix?
I guess there's the question we will still have yet to discuss of whether anything coming out of today's case merits changes to the code.
Yeah, so now would be the time to talk about it. So this is relating to looking at the language in the municipal code and the Political Reform Act to look at the definitions of
advertisements and online, what was it? Online platforms. Yes, online platforms. I guess my take is I'm a little bit unclear what such clarifications would be. As I mentioned before, the whole section of the code is around advertisements, and this whole case was around whether or not this medium posting was an advertisement or not. No money changed hands, so it's hard to see how you could argue that it was an advertisement, nor any kind of in-kind exchange of services. So I don't know. The only thing it sounded like the recommendation was to make sure that we are importing the Political Reform Act section on online platforms. Though I thought when I looked at that section, it sounded to me like, well, there was a section that said that a long list of things excluded by the PRA as advertisements is implicitly, and any further amendments is incorporated into the municipal code. I guess it didn't explicitly say that amendments to add new types of advertising are imported into the municipal code. Maybe that's what he was after.
Now, Tom, I have a slightly different view of kind of what that memo was about and why it was dismissed. I don't focus on whether or not the platform was paid to run something. I think it's just more generic. Is this a platform that accepts advertising and advertises, regardless as to whether it is based on, this particular item having been unpaid? But having said that, I don't see any need to deviate or carve out exceptions to the PRA.
Well, I don't think it was about carving out exceptions. I think it was about whether we were adequately importing what the PRA includes into the municipal code. And like said, my read of it was that we were, but there could be, I admit there could be some kind of reading where, maybe certain things were imported and other things were not explicitly imported, and that could be clarified, I suppose. I do think, though, even in the case of online platforms and the Facebook thing, the posts that are not paid for are explicitly excluded as advertisements in the PRA. In other words, if a campaign just adds a posting that's not paid for as an advertisement, that's not meant to be regulated under this, is my reading of it.
Yeah, what I think, so under the municipal code, as it talks about in that investigative report, we have an advertisement, a definition of advertisement for our regulatory schemes, but then it has the exclusion of commentaries or editorials being exempt. And then kind of relating back to the testimony we were provided from the complainant about how, in comparison between, for example, Matt Mahan's campaigns and how they did Medium publications, they always had a disclaimer at the end saying that it was like their opinion.
Yeah.
So maybe it's as simple as just like drafting some language that says commentaries and editorials should include a disclaimer that it's
that it should be clear that it's coming from the candidate or something.
Yeah, right.
I suppose, I guess the question is, can you require that? Is that a reasonable requirement to make? I mean, it doesn't seem unreasonable. On the other hand, I mean, the name for this posting was Irene Smith District 3, right? So it wasn't really ambiguous as to who was making the postings.
Yeah. I would say it's reasonable because I know for people like us, board members and commissioners, for example, there's city policy that when we write editorials, we're supposed to include a disclaimer.
Oh,
at the end
that it's not the opinion of the board.
Yeah. So I think that there's precedent to just have a simple requirement that says, please make sure you have a disclaimer.
Mm-hmm. I would, I'd be supportive of that. I think that makes sense as long as it sort of passes legal muster.
Okay. So how about we add that to the matrix, and then we can, if we'd like to make a motion, sorry to add this to your plate.
No,
Mr.
it's totally.
Christian, but draft some language and make sure that that is not going to cause any legal problems. So I'll make the motion. I move that we direct the city attorney's office to draft language to incorporate a requirement that candidates include a disclaimer at the end of editorials and commentaries that it's their own opinion. Is there a second?
I'll second that.
From Vice Chair Silver. Can we move to a vote?
Yeah, just a clarifying question. So you said candidates. Does this also apply to like a commentary from an independent expenditure committee?
It's a whole nother question.
I mean, obviously, so there with an independent expenditure, it's not, there's no ambiguity about whether it represents the position of the city council or something like that. But I think the issue was also kind of does the person writing the commentary have an agenda for or against a certain candidate or some other organization, right?
Well, I think in that case, if it is an independent expenditure, it might be considered an advertisement and have its own regulatory scheme for disclaimers.
Well, but not if it's an op-ed, then it's not an advertisement.
I see what you're saying.
I mean, I think, in the light of sort of the other things we're doing with the subcommittee, we could we could take this on and have a dialogue with the attorneys about, what exactly is best to present here if we want to sort of explore some of these corner cases.
I'm completely fine with that. I was going to ask the clarifying question on if I would be providing a memorandum opining on this issue or just providing language. So I have to do that analysis, admittedly.
So I rescind my motion then, since we're not drafting language yet. And instead we can just add it to the matrix. And I guess we haven't discontinued the ad hoc with you and.
Yeah, we have not, I was going to get to that in the report, is that although we haven't met this past month, we haven't sort of closed down the committee, and we potentially could, there are a couple of open things we could continue to do in that subcommittee. Still a few months left. Yeah.
Would you be willing to take that on and we can inform?
Yes.
Lopez?
Yes.
Thank you. So that'll be an item for you to check in with Mr. Tolnay on.
Okay.
All right. Any other items from the matrix? I guess I do have one last one. And that was Vice Chair Silver's recommendation about rescinding complaints mid-hearing or mid-investigation. We don't often get someone like Mr. Barco, who was just very admitting or open to being like, yeah, okay, I agree with the report. Typically, even if a complainant sees a report that goes against their wishes, they usually just dig their heels in. I don't think that happens too often that we get someone as agreeable as Mr. Barco, but we don't have a process in place to say theoretically in a complaint like that last one, that before, for example, if the public hearing happens, the complainant sees the reports and then says, oh, you know what, it was a disagree, or it was a technical issue. I wasn't able to see that the report was filed because of an administrative issue, that they decide to withdraw and then maybe save us all time and money on not having to have the public hearing. I would be open to adding some.
Sounded like he had an opportunity to withdraw, or no, that was the other complaint. They had an opportunity to withdraw after the clerk's office got the complaint and told them that, in fact, the report was there or something. That was the first one, that was the Herbert, not Barco.
But I think that could be just like an extra item in the resolution in our investigative process to allow people to withdraw if they wish before hearing begins.
Okay.
Sounds good to you?
I've just done, a variety of administrative proceedings throughout my career, and I've never known any proceeding you're at that you couldn't withdraw. If you settle with the other party, you withdraw your complaint.
And not here in San Jose, you go big or you go home.
All right.
Once you start,
So
you can't stop.
this would be a case of updating that, not the code, but the procedure memo or ordinance.
Resolution. Yeah. I was looking for that answer in real time and was wondering the same thing, but
hard for me to see that this would be at all controversial.
Yeah, I can certainly look into that.
Okay, so let's add that to the matrix, incorporating the exit clause for complaints. Do you need a motion to move forward, Mr. Tolnay, or are you good if you just add this to your giant plate lunch here?
I'm fine with just adding it. I guess just for clarity's sake, procedurally, would that be an item that Mark was previously asking for a motion on? I'll mirror that if that's what he was doing, but if not, I'm fine just adding it to the list.
This would be new, because this is out of today's hearing.
But I think this question is like in the past, before taking on something that involves significant work, you wanted a consensus of the board. But if this is not significant amount of work, then it wouldn't necessarily be needed.
I think it's a small change to that resolution, so I'm fine.
So in that
without-
case, if it doesn't require a certain level of analysis and it's more of a matter of like, we agree this is a step we can add and it's just drafting language, then maybe we do take a vote to direct.
Okay.
All right, so I move that we direct the city attorney's office to prepare language to add a clause in our guiding resolution to create a way for complainants to revoke their complaints. Is there a second?
Second,
From Vice Chair Silver, and I'll move to a vote.
Lou Silver,
yes.
Tom Pavel,
Yes.
Adrian Gonzalez.
Yes,
That motion passes. Thank you.
thank you. All right. I don't know if we've added enough for the city attorney's office to do, but is there anything else that we should add? Since we are in these final couple months to wrap this up. Any administrative items from the city clerk's office?
None at this time, Chair.
Thank you. All right, so in that case, if there's no objections, I will conclude item 7A on the agenda, our discussion of the biennial review, and continue it to our next meeting, in which we will touch base with the city attorney's office and see where we're at with our many policy recommendations.
I just think that we should be, this doesn't require a motion, but we should take the time. I mean, we should expect to spend, some amount of time in the January meeting if we want to meet the February deadline.
Yeah.
Mhm.
Agreed. Okay. Are you looking to put down certain guidelines, or are you just saying that like when we get these items in January, there will be substantive conversation to make sure we're on board?
The latter. We should just be, just aware that we may
Yep.
take more than the usual time
Yeah.
on that agenda item.
Agreed. Okay, anything else in sub item A? All right, we'll now move on to the agenda, item 7B, Charter Review Commission. I think we can remove this from the agenda going forward. And I think I guess we didn't talk about it. Or maybe we did. So the one recommendation from the charter review was measure IH, elemental P,
Measure I.
measure I, that passed, I believe. Is that correct?
That's correct, Chair. Yes, it passed.
Thank you. So the Board of Fair Campaign and Political Practice will be protected in the charter. And I don't think there's any really follow-up work at this point relating to the Charter Review Commission, unless anyone has any other thoughts. See none, let's city clerk's office, let's discontinue this on the next agenda and call it done. All right, we'll move on to the next item on the agenda, 7C, status update on Code for San Jose. So this will be new for Mr. Tolnay, but last year we had built this partnership with Code for San Jose to essentially provide pro bono services to build a reporting platform for campaign finance. But the lead engineer stepped down to pursue other opportunities. And then he recently told me that the Code for San Jose organizer also just transitioned, but he gave me the contact information for the new coordinator for Code for San Jose. So I will eventually get that meeting set up with the new people. A lot of turnover this year. I wasn't so sure if they were going to continue to provide support, but Ryan, the last software lead, said that all of his language is accessible and he has all of his notes, and that they're set up to transition it to another engineering team. So I'll provide you all an update when we get that meeting set up. I do believe that Mr. Pavel volunteered last time that once we are able to set up a meeting, you'd like to be included. Is that correct?
It's more just that I'm willing to help out if there's anything useful to be done. This is somewhat in my area of experience, and so potentially I could be helpful here, but It all depends on what they're able to do. Yeah.
All right, I'll let you know as that picks up. Any other questions? Seeing none, we'll now move on to agenda item 7D, scheduling of a special board meeting if needed. I haven't heard anything, but I just want to ask the city staff if there's any updates if we need a special board meeting.
None at this time, Chair.
All right, any questions on this? Seeing none, we'll wrap up and go to item 7E on the agenda. Discussion of possible action on the ad hoc. Oh, I guess we already talked about this as a part of.
Yeah, I'm looking through my notes. I think we've pretty much covered everything. There's sort of no progress. Look forward to working more on this, the dark money disclosure ideas. And we had, yeah, potentially some other topics about office holder controlled committees for ballot measures. There was turned up in all this work, it turned up an article from like 5 years ago in the Mercury News about how that was a potential area of abuse. And the question is whether there's anything that we should do there. But that one we haven't really even started to discuss yet in the subcommittee.
Okay, so for now, the next steps are just to, as we discussed in the biennial review, just to follow up with Mr.
Yeah.
Tolman, talk about the language for implementation. All right, any questions on this one? Seeing none, we'll wrap it up. Now, item 8 on the agenda, new business. We have nothing listed today. So we'll move on to item 9 in the calendar or the agenda, public comments. City clerk staff, is there anyone present who wishes to speak during public comment?
We have one attendee, so Whitney, if you'd like to speak, would you please raise your hand? And we have no hands raised. Thank you.
Okay, thank you. We'll move on to item 10 on the agenda, meeting schedule. The next meeting is scheduled for January 12th, 2022 at 5:30 p.m. via remote teleconferencing. Any questions on this item? All right, seeing none, we'll now move on to item 11 on the agenda, adjournment. Is there a motion to adjourn?
So moved.
Motion from Vice Chair Silver, is there a second?
Second.
Pavel will now move to a vote.
Lou Silver,
Yes.
Tom Pavel,
Yes.
Adrian Gonzalez.
Yes.
Thank you. That motion passes.
Have a good new year, everybody.
Meeting is adjourned at 7
Yeah, you too.
p.m. Happy
Happy
holidays.
holidays, everyone.